whether written into their contract or not. Every employee has a duty to serve their employer faithfully, and this duty remains even when they resign and leave employment. A fiduciary duty is the highest standard of care, a legal obligation of one party, typically the fiduciary, to act in the best interest of another to whom they owe the duty, typically the principal or beneficiary. The rule arose out of the law of agency, and simply put, all employees are agents of their employers, and as such they have a fiduciary duty to act loyally for the principal's benefit in all matters connected with the agency relationship. Fiduciary duty is constituted by several obligations centred on the duty of loyalty, imposed on employees while in the employment of their employer. If they act adversely to the employer, they breach their fiduciary duty. Running a rival business while still employed is plainly a breach of the duty of fidelity. For example, in H&H Consulting Engineers and Myers, an employee who diverted work which could have been done by his then employer to his businesses he had a personal interest in was found to have breached his contractual fiduciary duty in order to pay compensation to his former employer. In Ampersam and Laundry, Judge Manasadaris of the Federal Circuit Court said the employee had an express duty to act with fidelity, as included in his letter of appointment and the company's own behaviour standards manual. In any event, the judge stated the law implied a term that is generally referred to as a duty to act with fidelity and good faith into every contract of employment. There is clearly a conflict between preparing to compete or work for a competitor and the duty not to act in any manner adverse to the employer's interest. Nevertheless, employees do have a degree of latitude in planning what they will do after leaving their current employer. As long as they do nothing to undermine their existing employer's business, the fact they have commenced planning may not breach obligations. In the same way, it would not usually be regarded as wrongful to apply for another job or talk to a prospective employer, even if a group of employees, while still employed, agree to start a competing business. In Scanwell Freight Express and Chan and Demerco Express at 479, the law allows employees a privilege to plan and prepare for competition in recognition of the competing interest of allowing the employee some latitude in switching jobs. However, this privilege is not without limitations, and there is a fine line between what is lawful and unlawful. In Libra Colleroy and Angle, it was held that an employee did not breach her obligations by truthfully responding to a client's query that she would be establishing her own business, as the statement was made in response to a direct question, and the court considered no element of solicitation was involved. Although an employee may prepare to compete with their employer while still employed, there are a number of acts that will be regarded as breaching the duty of fidelity, which include, but are not limited to, soliciting the employer's clients to switch to the new business. Ransom and Customer Services plc considered the actions of an employee who resigned and set up a business. During his notice period, he met with clients of his employer and discussed his future plans. So an employer wishing to create fiduciary duties needs to be careful that the contract clearly specifies the obligations an employee is under. Recruiting other staff presently working for the employer, as occurred in Schindler Lifts and Nebelak, is another act regarded as breaching the duty of fidelity. As is deliberately removing, copying or memorising any of the employer's valuable information. Robin Green confirmed fiduciary duty may be breached by an employee preparing a list of his employer's customers. Employees are not allowed to use copyright protected material without consent from their previous employer, and their new employer may also be in breach if they are using copyright protected material. Assisting a rival business the employee intends joining breaches the duty of fidelity. In Spotless Group and Blanco Catering, Justice Foster of the Federal Court upheld allegations that an employee who established and strived to advantage his personal company at the cost of his employer was in breach of numerous employment and other obligations both during and after the period of employment. Not misappropriating confidential information or trade secrets of the employer by sharing that information with the new employers may also breach the duty, as confirmed in Food Services of America and Carrington. So, the remedies. As fiduciary relationships arise in equity, there was a wide range of remedies potentially available. The most common being injunctions, which is an order restraining the fiduciary from committing a breach; rescission, an order setting aside an impugned transaction; account of profits, an order stripping the relevant gain or profits from the fiduciary; equitable compensation, an order for compensation for a loss suffered by the beneficiary, with the aim of restoring the beneficiary to the position they would have been in if there had not been a breach; imposition of a constructive trust, an order that the fiduciary hold property on trust for the benefit of another party. If an individual breaches the fiduciary duties, they would need to account for the ill-gotten profit with their beneficiaries entitled to damages, even if they suffered no harm. Employees also owe obligations to you as an employer in relation to Section 183 of the Corporations Act 2001 Commonwealth, which sets out that an employee of a corporation who has gained information as a result of their role must not improperly use the information to gain an advantage for themselves, another person, or cause detriment to the business. So there are two key points. First, if there is any potential doubt, make sure the irrelevant agreement or deed expressly identifies whether fiduciary obligations are intended to apply. If they are, the document should explain the nature and extent of those obligations. It is vital to ensure your employment agreement covers detailed post-employment obligations in relation to non-compete, non-solicitation, confidentiality, intellectual property and termination. If you believe your employee is in breach of any of their contractual, common law or statutory obligations, take immediate action. Second, ensure the fiduciaries emphatically understand the scope of their duties. As explained, it is an obligation of utmost honesty and good faith, and they can be held to account even when you have not suffered a loss or been able to take advantage of the relevant opportunity. When contemplating proceedings based on a breach of fiduciary duties, be careful to select the remedy that is likely to provide the best return. If the profits earned by the employees as a result of the breach are likely to be greater than the loss sustained, an account of profits should be claimed. If not, equitable compensation should be. It is also important to point out that resignation does not necessarily absolve an employee from their fiduciary duties, as some survive termination of the employment relationship. You should be reassured by Justice Foster's decision, as it confirms employees may owe duties beyond those in the employment contract. So within the employment contract, we must include a post-employment constraint to restrain or stop the employee from taking clients with them after their employment ends, or contracting them for a set period, taking employees or suppliers, or owing or working for a competing business. An intellectual property clause that aims to set out that the employer will own any intellectual property that the employee creates. Further, the employee must not use the intellectual property of the employer unless in the course of employment. A confidential information clause that aims to protect your confidential information gained during employment and sets out that employees cannot use such information post-employment. A termination clause that sets out the employee's post-employment obligations to return property and confidential information. It is imperative in the contractual obligations of post-employment restraints to have cascading clauses, such as optional clauses, to ensure the court has the flexibility to select the most reasonable restraint. You may also choose to have an exit deed or deed of settlement that is signed by both parties setting out the other terms. Added to this, the employer usually provides an additional payment when asking the employee to sign an exit deal. The deed should state that the employee will not make any further claims or take legal action in relation to the termination of their employment. Thank you.